Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about the Biometric Information Privacy Act, which was passed in 2008 in the state of Illinois. It is currently still the most stringent data privacy law in the United States having to do with biometric data. So this law says that any company handling biometric data of any consumers needs to get their consent, needs to be able to inform them about what they're planning to do with the data, how long they're going to keep the data, when they will delete the data, and not to sell it without the prior permission or consent of the consumer. The reason why this is a big deal in the state of Illinois and for any other company in the US that handles Illinois biometric data is that the law has been interpreted to mean that a per incident damage fee can be charged to companies who mishandle biometric data or does not follow this law. So the fee or the fine for mishandling or misuse of customer data against the BIPA can be as low as $1,000 or as high as $5,000 per incident. So that means, for example, if you are employed by a company and they take your fingerprints, say you have a login or log out system that they're using your fingerprints for, every time that you punch in and punch out, that may be considered an incident. So it's, $1,000 or $5,000 per incident if companies run afoul of this law. So as it is, companies are very concerned about it. Illinois residents are very concerned about it. But also in terms of the federal government and federal legislation, things like the CCPA in California deal with biometric data more broadly, but also other states are enacting laws having to do with biometric data that aren't yet as stringent as the BIPA law. Currently, there's a big case that is a class action against Facebook saying that for a period of time in the state of Illinois, Facebook was tagging photos of individuals in the state of Illinois without their proper either consent, the information related to how long they were going to retain the data, what they were going to do with the data, and when it would be deleted. So this case, if it should go forward, has been calculated at being worth possibly $35 billion because, again, they're using it as per incident. So, for example, anytime your photograph is taken, anytime that your fingerprint is used, anytime your voice or any other biometric information is used about you in the state of Illinois, you have rights as a consumer to ask or request information, and the businesses have a right to proactively provide information about how they're using the data, and even must do so not only proactively, but they should do it before the collection of the data occurs. So these laws, or this particular law having to do with biometric data, is going to be a really hot topic because we're going to start to see a lot of big cases in the news having to do with class action lawsuits that are filed because of how data is being used of Illinois residents. So to wrap it up, the BIPA law is about biometric data, any biometric data that's collected by any company, and it has to do with consumers' rights to have transparent knowledge of how companies are collecting, using, disposing of, or even selling, which they're not supposed to do, of the data. So that is the BIPA law in a nutshell. Thank you.